Baby, come give me something, oh.
If your employer rejects your unemployment claim and then you receive a notice from the EDD stating that your unemployment claim is denied, you need to appeal that thing. You have 30 days to appeal it. In that appeal, you need to make sure that you do not admit to anything that qualifies as misconduct under the UI code. And then if they fired you, you have to say that they were the moving party to terminate you. You did not move to termination and you did not voluntarily quit. If your appeal is granted, you will receive a hearing in front of an administrative law judge along with the employer and the employer's lawyer, and then you're going to be there sitting by yourself. You also have the right to have a lawyer there too, but how this situation goes is the administrative law judge is going to question you. They're going to directly question you about how you left the company. Then the other party, your employer's attorney, is going to be able to cross-examine you on why you left the company. That gets intimidating, but you have to be prepared. You have to be ready. And then the judge is going to question the employer about how you left. And you have the opportunity to cross-examine that person. You have the opportunity to be the lawyer in this. And then they make a decision. This is actually a really good question too. In the year 2020, in the state of California, if your employer sexually harasses you, you have 3 years to file a complaint with the Department of Fair Employment and Housing. People call that the DFEH. But I would contact an attorney before you do that. You know, there are people who provide resources for people who are victims of sexual harassment at work. I'm actually working on one. But I know our firm does provide free consultations for women and men who are sexually harassed or sexually assaulted at work. But you need to remember, document, document, document. And one thing that we're going to let you know is that you need to go through the employer's processes first, which means you still need to report it to HR. I recently received an employment-related question in my DMs, and I think it would benefit the whole class if we answered it out loud. The person did give me permission to do so. This is a really good question. And I'm going to pause this while I'm out of the way so you guys can pause the video so you can read the question on your own. But the question says, question, I was fired today but with an effective date of tomorrow, but my employer says that they don't owe me payment in lieu even though they don't have my last paycheck. And because of COVID-19, they don't have to pay me until next Friday, a week from today. Is that a thing? Short answer, no. We all know California Labor Code Section 203 provides a strict deadline for your employer to provide you your last paycheck. If you quit, they need to provide you your last paycheck within 72 hours. If you're fired, they need to provide you your last paycheck that day. There are some exceptions to waiting time penalties, but this is not legal advice, but I mean, just looking at it, it seems like your employer knows today's your last day and they're choosing not to pay you today and they're choosing to pay you next Friday. They're not supposed to do that. Did you know that there are entire class actions based on employees not receiving proper pay stubs? Think about it. It's $50 for the first violation and $100 for every violation afterwards, up to $4,000 per employee. Multiply that by 100 employees. If you're on unemployment in California right now, and then your employer calls you up and says that as soon as shelter in place is done, you're terminated, your unemployment will be unaffected. When you first received your unemployment, you had a set amount of money that you could draw from. That money is slowly running out. That number decreases every week, then it's done. Hey Nana, this is a really good comment. Thank you for asking. You are partially correct. In the state of California, if you are terminated, your employer is required to provide you your last paycheck that day. If you quit, your employer has 72 hours to give you your last paycheck. Now that California is starting to open up, we got to be careful. If you're on unemployment and your employer requires you to go back to work, you need to go back to work. If you are at risk, if you have diabetes, if you live with someone who's at risk or has diabetes, unfortunately, that's not an excuse. If you don't go to work, your employment benefits will shut off. This is huge, guys. The Supreme Court has just ruled that the existing civil rights laws, so Title VII or the Civil Rights Act of 1964, that typically protected workers from discrimination or harassment in the workplace under a certain set of protected classes, such as race, gender, sex, ethnicity, disability. Those same civil rights laws are now extended to transgender and LGBTQ individuals. Now, with those existing laws, you are unable to discriminate in the workplace based on someone's sex orientation or if they are transgender. Now, you would think that this law would already be in place, and in a lot of states it actually already is. However, in federal courts, sometimes there's lesser protections federally than what some states have within their own state laws. This is just another step in the right direction to prevent workplace discrimination across the U.S. If your boss sends you a picture of his junk, number one, that's sick, and number two, that's sexual harassment. Then make sure you report it to HR and start documenting the things that happened to you afterwards. You got to be careful for retaliation in these situations because the employer might strike back. So make sure you keep good notes and have wit. Hey Miguel, thanks for asking. Actually, I'm a California attorney and I'm located in the San Francisco Bay Area. A lot of the information you're going to see on this is only based on California or federal law. So stay tuned and share with your friends. It's amazing how many employers are trying to get their employees to buy things. If your employer requires you to purchase anything for your job, anything, California Labor Code Section 2802 requires them to reimburse you for it. Now let me read this out loud. An employer shall indemnify his or her employee for all necessary expenditures or losses incurred by the employee in direct consequence of the discharge of his or her duties, or of his or her obedience to the directions of the employer, even though unlawful, unless the employee at the time of obeying the directions believed them to be unlawful. So what that means is, even if your managers tell you, hey, go buy this thing for me because we need it to complete this business, yeah, you need to be reimbursed for that. And it doesn't have to be in writing, but just for your case, you should verify it in a text message or an email, or even write a handwritten note. Too many times I see employers just trying to get their employees to purchase items that the employers should have. For example, masks and gloves.